సీనియర్ అడ్వకేట్ గారు వారు పవర్ పాయింట్ ప్రజెంటేషన్ తో మనకు తెలియజెప్తారు. దయచేసి ఆ పవర్ పాయింట్ ప్రజెంటేషన్ కు మీరు అక్కడ అడ్డం రాకుండా ఉండండి. సార్ క్యారీ. థ్యాంక్ యూ. సభలో ఉన్న పెద్దలందరికీ నమస్కారం. ఈ 7 జడ్జిలు ఇచ్చిన జడ్జిమెంట్ మన దేశంలో అఫర్మేటివ్ యాక్షన్ ఏదైతే కాన్స్టిట్యూషన్ ద్వారా ఇంట్రడ్యూస్ చేయబడిందో 1950లో, దాని ఇంప్లిమెంటేషన్ అనుభవాలు, రాష్ట్రాలు చేసిన చట్టాలు అన్నిటినీ పరిగణలోకి తీసుకుంటూ మన రాష్ట్రం నుంచి వచ్చిన జడ్జిమెంట్, ఇవి చిన్నయ్య గారి జడ్జిమెంట్ కరెక్టా కాదా అన్న క్వశ్చన్ డౌట్ రేస్ చేయడం వల్ల ఆ జడ్జిమెంట్ రెఫరెన్స్ ద్వారా 7 జడ్జిల దాకా వచ్చింది. ప్రైమరీ క్వశ్చన్ ఏముంది అంటే, మన కాన్స్టిట్యూషన్ ఒక స్కీమ్ ఇచ్చింది, అందరూ సమానంగా ఉండాలి అని. ఆ స్కీమ్ ఆధారంగా మన కాన్స్టిట్యూషన్ ఇంప్లిమెంట్ చేయడానికి ఫండమెంటల్ రైట్స్ ఇచ్చాడు. మన ప్రియాంబుల్ ఒక గైడింగ్ లైట్ ఉంది, ఆ తర్వాత డైరెక్టివ్ ప్రిన్సిపల్స్ ఆఫ్ స్టేట్ పాలసీ ఉంది. ఈ 3 కలిపి మన దేశము, ప్రజలు అందరూ సమానంగా ముందుకు జరగడానికి అవసరమైన ఉపాధి కల్పించడం, అవకాశాలు కల్పించడం అన్న బాధ్యత, కాన్స్టిట్యూషనల్ రెస్పాన్సిబిలిటీ మన స్టేట్ సెంట్రల్ గవర్నమెంట్ల మీద ఉంచడం జరిగింది. ఆ క్రమంలో మల్టిపుల్ ఎఫర్ట్స్ డిఫరెంట్ గవర్నమెంట్స్ చేస్తూనే ఉన్నాయి. గవర్నమెంట్ ఎఫర్ట్స్ అన్ని యాజ్ అ మ్యాటర్ ఆఫ్ కాన్స్టిట్యూషనల్ డిసిప్లిన్ have been challenged before the constitutional courts, and judicial review, which is a part of a basic feature of the constitution. Judicial review prakaram high court gaani supreme court gaani aa decision making process ni examine chestayi. So a contours of the judgment enti, mana constitutional scheme enti annadi ee PowerPoint presentation ద్వారా నేను ప్లేస్ చేస్తాను. ఆ తర్వాత ముఖ్యంగా ఈ 7 జడ్జిల జడ్జిమెంట్ లో మెజారిటీ అండ్ మైనారిటీ ఒపీనియన్స్ ఉన్నాయి. ఆ మెజారిటీ ఒపీనియన్ లో మూలంగా చెప్పబడుతున్న పాయింట్స్ ని మాత్రమే హైలైట్ చేసినంత వరకే నేను రిఫర్ చేస్తున్నాను. దిస్ ప్రెజెంటేషన్ ఈజ్ నాట్ ఎ కాంప్రిహెన్సివ్ ఎక్సర్సైజ్. ఇట్ ఈస్ ఓన్లీ కన్ఫైన్డ్ టు ది జడ్జ్మెంట్ అండ్ ది పోర్షన్స్ విచ్ ఐ ఫెల్ట్ షుడ్ బి హైలైటెడ్ హావ్ బీన్ సెలెక్టెడ్. సో హర్యానా 94లో తీసుకొచ్చింది, ఆంధ్రప్రదేశ్ 2000లో తీసుకొచ్చింది, పంజాబ్ 2006లో అండ్ తమిళనాడు 2009లో. ఈ 4ని కన్సిడర్ చేశారు సబ్ క్లాసిఫికేషన్ ఎఫర్ట్స్ బై డిఫరెంట్ స్టేట్ గవర్నమెంట్స్. పార్ట్ 3, ద క్రక్స్ ఆఫ్ ది ప్రాబ్లమ్ ఈస్ ప్రెసిడెన్షియల్ ఆర్డర్. ఒకసారి ఓ స్టేట్ కి ఇచ్చిన తర్వాత షెడ్యూల్ కాస్ట్ ని డిక్లేర్ చేస్తూ, డస్ ఇట్ డిక్లేర్ వన్ homogeneous schedule caste in the sense of one caste, homogeneous caste for the state, or it has multiple individual identities subsumed within the schedule is the question. So that is the core of this entire discourse and discussion. Next question is whether subclassification amongst the scheduled castes within the presidential order. మనం ఒకటి క్లియర్ గా అర్థం చేసుకోవాల్సింది ఏంటంటే, సబ్ క్లాసిఫికేషన్ అన్న మాట వచ్చినప్పుడు ఇట్ ఈస్ కన్ఫైన్డ్ ఓన్లీ టు దోస్ హూ ఆర్ already included in the presidential order for each state. I repeat, only those castes which are enumerated in the presidential order for the state, within that whether a subclassification is permissible or not is the scope of this entire judgment. They are not looking at state governments introducing new castes into the presidential order, which is not permissible. So that is not even a part of the discussion. That is not even a concern of this judgment. Then the 5th part is the way forward. ఇప్పుడు ముందుకు ఎలా వెళ్ళాలి అన్నది కూడా ఈ జడ్జ్మెంట్ లోనే వాళ్ళు ఒక మార్గదర్శకం ఇవ్వడం జరిగింది. ఆ తర్వాత కంక్లూజన్స్, ఏది నిష్కర్షంగా ఉంది అన్నది. దీనిని బట్టి మీ డిస్కషన్ ని వాళ్ళ మీరు ఫ్రూట్ఫుల్ గా ముందుకు తీసుకెళ్ళచ్చు. ఫస్ట్ పార్ట్ వచ్చి ప్రియాంబుల్. మనకి ప్రాబబ్లీ ప్రియాంబుల్ అందరికీ పరిచయమే. Justice, social, economic and political. Now this justice, social, economic and political justice is what the social justice debate this country has always been promoting and encouraging. Social justice to every individual, every group, every subgroup, every identity. So therefore, that is the core of this entire discourse. Equality of status and opportunity. Again, equality ante enti? Mana constitutional equality article 14 lo unnadi matramena leda 15, 16 are exceptions to article 14 leda they actually supplement the concept of equality and they are together a package for promoting equality అన్న ఇష్యూలో కూడా సుప్రీం కోర్ట్ జడ్జ్మెంట్ చాలా క్లియర్ గా ఇండికేషన్స్ ఇచ్చినాయి. మన పార్ట్ 3 రైట్స్ ఆర్ a combination of various aspects of our rights, so we should not look at them as individual silos. కేశవానంద భారతి దగ్గర నుంచి సో ఇండివిజువల్ గా ఒక్కొక్క రైట్ ని సపరేట్ గా ఎగ్జామిన్ చేయకూడదు. దే ఆర్ ఎ స్కీమ్. సో ఒక స్కీమ్ లో చూస్తే ఆర్టికల్ 14, 15 and 16 మూడు ఒక స్కీమ్ ఆఫ్ ఫండమెంటల్ రైట్స్ టు ప్రమోట్ ఈక్వాలిటీ. మూడోది ఫ్రెటర్నిటీ, భాతృత్వం. అంటే ఏంటి? ఇప్పుడు మనకు క్లాసికల్ గా చెప్పాలి అంటే మన ఒక ఇంట్లో అన్నదమ్ములు ఉంటే మన అందరికీ మన చుట్టుపక్కల ఉన్న చూసిన దాని ప్రకారం చిన్నప్పుడు మా అన్న వస్తాడు అన్న ఒక ధైర్యం ఉంటుంది. చిన్నపిల్లలకి ఏమైనా గొడవలు అవుతున్నా ఏదో అవుతున్నా. సో ఒక సెన్స్ ఆఫ్ సెక్యూరిటీ ఫ్రమ్ అన్ ఎల్డర్ బ్రదర్ టు ద యంగర్ బ్రదర్ అండ్ మా తమ్ముడు ఉన్నాడు అన్న ధైర్యం ఒక తమ్ముడికి అన్నకి ఉంటుంది. సో ఇఫ్ యు ఎక్స్ట్రాపోలేట్ దిస్ ఫ్రెటర్నిటీ ఇంటూ అ నేషనల్ లెవెల్, ద స్ట్రాంగర్ పర్సన్, ది వైజర్ పర్సన్, ది మోర్ knowledgeable person is cast with the duty, the constitutional duty to create space for the weaker and to accommodate them and then give them a lending hand to ensure they also reach to their potential. So Article 14 మనం చూసాము ఈక్వాలిటీ. Article 15 లో నేను హైలైట్ చేసేదలుచుకుని 15(4) ప్రస్తుత సందర్భంలో nothing in this article or in clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes and scheduled tribes. So 15(4) talks about advancement of any socially and educationally backward classes of citizens or for the scheduled castes and the scheduled tribes. So therefore there are three buckets here. Socially and educationally backward classes of citizens which are other than scheduled castes and scheduled tribes. So 15(4) recognizes these three buckets. Now when you see 16, equality of opportunity in matters of public employment. Look at the language of 4. Nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any backward class of citizens which in the opinion of the state is not adequately represented in the services under the state. So ivalati me discussion ki E15(4) will be the guiding light and how it has been interpreted in the present judgment. Endukante 15(4) లో మూడు buckets ని విడివిడిగా ఐడెంటిఫై చేశారు. 16(4) కి వచ్చేసరికి any backward class అన్నారు. So what they did is they have clubbed all the three buckets in 15(4) into one descriptive expression called any backward class. So that is the constitutional distinction as drawn original in the original constitution. Now special provisions for SC and ST. Now who are scheduled castes? The president may, I am reading article 341 of the constitution. The president may, with respect to any state or union territory and where it is a state, after consultation with the governor thereof, for public notification specify the castes, races or tribes or parts of or groups within castes, races or tribes which shall for the purpose of this constitution be deemed to be scheduled castes in relation to that state or union territory as the case may be. Parliament may by law include in or exclude from the list of scheduled castes specified in a notification issued under clause 1 any caste, race or tribe or part of or group within any caste, race or tribe, but save as aforesaid notification issued under the said clause shall not be varied by any subsequent notification. So this is the definition clause which I am going to place. In this constitution, unless the context otherwise required, the following expressions have the meanings hereby respectively assigned to them, that is to say, scheduled castes mean such castes, races or tribes or parts of or groups within such castes, races or tribes as are deemed under Article 341 to be scheduled castes for the purposes of the Constitution. So, definition clause Article 366(24) ఏం చెప్తోందంటే, there is a deemed class under 341 which comprises of such castes, races or tribes or parts of or groups within such castes, races or tribes as are deemed under Article 341 to be scheduled castes for the purposes of this constitution. So, మనం చూసింది ఏంటంటే 341, 366(24) కలిపి చూస్తే they have pooled together multiple identities with reference to caste, race, tribe or parts of or groups within such castes, races or tribes as are deemed under Article 341. And 341(2) talks about inclusion and exclusion from the scheduled caste list. So one thing is very clear, as per the original constitutional language itself, that this presidential order is a dynamic order which can be added to or which can be, some can be removed from the list, excluded from the list. So that is the constitutional scheme. And then there are reservations, provisions 330, 332, 334, claims of scheduled castes and scheduled tribes under 335, and then there is a National Commission for Scheduled Castes. So this is a commission at the national level which is part of the constitution itself. Now if you look at Article 338(5), it shall be duty of the commission. So it's a constitutional duty on the National Commission for Scheduled Castes. Now what are the duties? There are multiple duties. I would like to save on time and refer to C. To participate and advise on the planning process of socio-economic development of the scheduled castes and to evaluate the progress of their development under the union and any state. So there is a constitutional duty on the National Commission for Scheduled Castes under Article 338(5). 338(5)(d) to present to the President annually and at such other times as the Commission may deem fit reports upon the working of those safeguards, to make in such report recommendations as to the measures that should be taken by the Union or any state for the effective implementation of those safeguards and other measures for the protection, welfare and socio-economic development of the scheduled castes. So therefore there is a very clear role defined under the Constitution to the National Commission for Scheduled Castes. Then the 7th schedule to the Constitution, which is read to be read with Article 246, Union list to state list and concurrent list. From here we come to the state legislations for subclassification of scheduled castes. The first, the one which is noticed, I've given the reference also in the presentation. Justice Chandrachud Gari judgment lo idi refer ayindi. Notification dated 9th November 94, issued by State of Haryana. The government of Haryana issued notification by which scheduled castes in the state were classified into two categories, Block A and Block B. Block B consisted of 5 castes, whereas Block B consisted of remaining 36 castes in the list. Within the quota reserved for scheduled castes in direct recruitment for government jobs, 50% of the vacancies were to be offered to candidates from Block A and other 50% to be offered from the candidate from Block B. Andhra Pradesh, manandarki telisinde idi, EV Chinnaya gari challenge అయిన subject ఇది. So there were A, B, C, D clauses and 1% for A and 1% for the other, and then 6 and 7% for the remaining groups for the. This was the subject of challenge, and the Supreme Court said the state government or the state legislature cannot tinker with the presidential order and they cannot subdivide the presidential order scheduled castes. Similarly, Punjab also had a Reservation in Services Act 2006. Tamil Nadu also had a similar act. Now, the first point that which comes to our mind is whether scheduled castes are homogeneous or not. Homogeneous ante, is there any common identity which actually anthropologically or sociologically binds them, other than backwardness, being the depressed classes, being the Harijans, being the people who were oppressed for centuries and recognized by the Constitution itself as their operation has been such that they were recognized by the original language of the Constitution itself, that they needed some kind of a affirmative action to make the right of equality meaningful for them by providing special provisions under 15.4 specifically and 16.4 clubbed together. So now the scheme of the judgments I have placed here. The first judgment of 76 says that scheduled castes attain a new status by a presidential notification and are not a homogeneous group. This is 7 judges bench judgment in N.M. Thomas. That has been actually accepted in the current judgment also. Indra Sani judgment, though it was primarily concerned with the backward classes other than scheduled castes and scheduled tribes, there were observations in that judgment also which said some castes for it cannot be denied that scheduled castes include quite a few castes. So this is a 9 judges bench. Then we have E.V. Chinnaya, which takes a completely different view. Scheduled castes form a homogeneous group by a constitutional design. Subclassification within the presidential list is impermissible. So this is precisely what the Supreme Court 5 judges held in the AP legislation, in the undivided state of AP. Then the state of Punjab versus Davinder Singh, again a 7 judges bench, acknowledges that heterogeneity within scheduled castes, historical disparities and unequal treatment justify subclassification, and they question the correctness of E.V. Chinnaya. So 7 judges in 2024. And then this is the judgment which we are discussing. Justice K.K. Matthew in N.M. Thomas, certain observations I want to place. This is all quoted in the present judgment under consideration. The word caste in Article 16.2 does not include scheduled castes. The definition of scheduled castes in Article 366.24 means such castes, races or tribes or parts of or groups within such castes, races or tribes as are deemed under Article 341 to be scheduled castes for the purposes of this constitution. So, scheduled castes in terms of Article 341 read with 366.24 can also include certain tribes as scheduled castes. That is the constitutional description of scheduled castes. This shows that it is by virtue of the notification of the president that the scheduled castes come into being. Though the members of the scheduled castes are drawn from castes, races or tribes, they attain a new status by virtue of the presidential notification. Moreover, though the members of the tribe might be included in scheduled castes, tribe as such is not mentioned in Article 16.2. A classification is reasonable if it includes all persons who are similarly situated with respect to the purpose of law. In other words, the classification must be founded on some reasonable ground which distinguishes persons who are grouped together, and the ground of distinction must have rational relation to the objects sought to be achieved by the rule or even the rules in question. It is a mistake to assume a priori that there can be no classification within a class, say that lower division clerks, if there are intelligible differentia which separates a group within that class from the rest, and that differentia have nexus with the object of classification, I see no objection to a further classification within the class. In Indra Sani, the observation is, we are of the opinion there is no constitutional or legal bar to a state categorizing the backward classes as backward and more backward. We are not saying that it ought to be done. We are concerned with the question if the state makes such a categorization, whether it would be invalid, we think not. E.V. Chinnaya judgment stands overruled now. I'll move on. The state of Punjab versus Davinder Singh. This is the judgment which is the binding law in the country today, as declared by the Supreme Court in August 2024. Justice Gavai Garu has given a very detailed judgment. I've extracted from his judgment and Justice Chandrachud's judgment, which is also on behalf of Justice Manoj Mishra. Justice Satish Chandra Mishra, Sharma, Justice Vikram Nath, and Justice Pankaj Mittal agree with both these opinions. So therefore, for convenience of time and also to make things more clearer and not confusing, I have confined my presentation to these two lead opinions and extract from these two lead opinions, with the reference to para and page number. So, what the Chinnaya case, Justice Gavai Garu is saying, to ascertain if Chinnaya is good law, I will have to first examine whether the finding in E.V. Chinnaya that N.M. Thomas 7 judges held that scheduled caste to be homogeneous group is correct or not. So Chinnaya's 5 judges came to a conclusion that the earlier 7 judges' judgment in N.M. Thomas had declared that scheduled castes are homogeneous. So it was under that understanding of the earlier judgment that Chinnaya proceeds. That scheduled castes have been declared by a 7 judges bench of the Supreme Court in N.M. Thomas to be homogeneous. So therefore, the state legislature could not have subclassified them. That is what the premise of E.V. Chinnaya was. The learned judge N.M. Thomas, in the N.M. Thomas case, further observed that the Indian jurisprudence has generally regarded scheduled castes and scheduled tribes not as a caste, but as a large backward group deserving social compassion. However, on reading of the majority judgments in N.M. Thomas, it does not show that the scheduled castes are homogeneous group and subclassification therein is not permissible. It can thus be seen that in none of the judgments in N.M. Thomas, it is held that the scheduled castes are a homogeneous class. It has been held that once the scheduled castes and scheduled tribes have been identified and they find a place in the presidential list, they will continue to be the scheduled castes and scheduled tribes. It has been held that by the very fact of they being included in the presidential list, they are deemed to be backward and no further inquiry regarding their backwardness would be warranted. The ground realities cannot be denied. Even among the scheduled castes, there are some categories who have received more inhuman treatment for centuries and generations as compared to the other categories. The hardship and the backwardness which these categories have suffered historically would differ from category to category. In my view, therefore, merely because they are part of a single or a combined presidential list, it cannot be said that they form part of a homogeneous group. I therefore have no hesitation in holding that E.V. Chinnaya has been wrongly decided. So this is what Justice Gavai says, that scheduled castes, though for the convenience are referred to as scheduled castes, they actually are a group of castes, groups, tribes or parts thereof, which have been put together in a common presidential order, and they are referred to as scheduled castes. But that per se does not make it a caste by itself. That seems to be the gist of this conclusion. Justice Chandrachud in this regard. Dr. B.R. Ambedkar highlighted that applying a uniform criteria to identify the different depressed classes would be inappropriate. Dr. Ambedkar observed that the differences in the tests of untouchability do not indicate differences in the conditions of the untouchables, because the notion underlying both the standards would be the same, that is, below the dignity to interact or touch persons of certain castes. He observed that the difference in the rigidity with which untouchability is practiced does not eliminate the notion of such a practice. This indicates that the depressed classes were identified based on the notion of untouchability and not in the literal sense of the term. The effect of adopting a notional and not the literal test is that the social condition of all the castes included within the depressed class is not uniform. So the Government of India Scheduled Caste Order 1936 did not exactly correspond to the list published by Hutton or the provincial franchise committees. The inclusion and exclusion to be broadly matched. Now we come to the next question. So we broadly agree on the question of homogeneity. Part 4 of my presentation. Whether subclassification is permissible or not. This is Gavai's opinion. I am reading from the extract from that. As already discussed here in above, the 9 judges bench of this court in Indrasani has, in unequivocal terms, held that the further classification of backward classes into more backward classes is permissible in law. However, in paragraph 803, Indrasani, Justice Jeevan Reddy specifically observed that under Article 16.4, there is no mention of scheduled castes and scheduled tribes, and that scheduled castes and scheduled tribes are also part of backward class of citizens. That being the case, if the scheduled castes and scheduled tribes are a part of backward class of citizens under Article 16.4, then the question would be as to why subclassification, which is permitted in case of other backward classes, cannot be permitted in case of scheduled castes and scheduled tribes. So this seems to be the basis. As already discussed here in Perf, it has been held that further classification of backward classes into backward and more backward classes is permissible under the Constitution. The only caveat put by Savant Justice is that if it is done, there has to be a reservation for both backward as well as for more or most backward classes. It has been held in Indrasani that under Article 16.4, the scheduled castes are also included in the terms of backward classification. As already discussed here in above, this court in Indrasani has said that further classification of backward classes into backward and more backward classes is permissible in law. By that corollary, if the state finds that any of the castes, races, tribes, or part of or groups within the castes, races, or tribes are not adequately represented, could the state be denied its right to make a special provision for that? I find that, as has been observed by this court in various judgments, it is the duty of the state to give preferential treatment to the backward classes of citizens who are not adequately represented. If the state, while discharging that duty, finds that certain categories within the scheduled caste and scheduled tribes are not adequately represented, and only the people belonging to a few of the categories are enjoying the entire benefit of reserve for scheduled castes and scheduled tribes, can the state be denied its right to give more preferential treatment for such categories? In my view, the answer would be in the negative, since the same would not amount to tinkering with the presidential list. So basically what they hold is that scheduled castes per se under Article 345, 341 presidential orders are a group of individual identities which have been brought together and they do not form a homogeneous group. That leads to the corollary, the sequitur being that subclassification within such group which is declared to be a presidential order scheduled castes are permissible in law. That is the conclusion on both questions which came to the court. So now the court deals with the way forward. First is Justice Gawai. That leaves us with the question regarding the applicability of creamy layer principle to the scheduled castes and scheduled tribes. No doubt that in Indrasani, Homogeneity, while considering the applicability of means test and creamy layer, has observed that the discussion therein is confined only to other backward classes and it has no relevance in the case of scheduled castes and scheduled tribes. So the court was conscious of this observation. His Lordship gave an example that if a member of a designated backward class becomes a member of IAS or IPS or any other All India service, his status in society rises. He is no longer socially disadvantaged. His children would get full opportunity to realize their potential. They are in no way handicapped in the race of life. It is observed that it is logical that in such a situation, his children are not given the benefit of reservation. It is further observed that by giving them the benefit of reservation, other disadvantaged members of that backward class may be deprived of that benefit. Rejecting the argument of one swallow doesn't make the summer, that is, merely because few members of a caste class become socially advanced, the caste class as such does not cease to be backward. The learned judge answered that though clause 4 of Article 16 aims at group backwardness, he was of the view that the exclusion of such socially advanced members will make the class a truly backward class and would more appropriately serve the purpose and object of clause 4 of Article 16. So what they are trying to say here is that people who originally belong to this socially disadvantaged group, having availed the benefits, have moved ahead or climbed the ladder and they become probably IAS, IPS, the senior bureaucratic positions, which gives them the power to formulate policies also on behalf of the state. They are definitely put in a very different social status and their families and their children fall in a different group as compared to people of their own subcaste or the identity of the same caste who still probably are suffering with social disadvantages. So by virtue of climbing the ladder, they cease to be part of the socially disadvantaged group, and that is a measure by which the creamy layer principle could be examined, is what is being referred to here. Again in paragraph 98, he observed that the administration may well innovate and classify, weed out the creamy layer of scheduled caste and scheduled tribe. However, he cautioned that the court cannot force the state in that way out. So therefore, the court cannot issue a mandamus for subclassification. So nobody can go and ask the court that please direct a policy to be evolved for subclassification. Because the court consistently have recognized that policy is exclusive domain of the executive and in consonance with the legislative powers which are vested in them under Schedule 7, which are coterminous. Justice Chinnapareddy also records that a few members of those castes or social groups may have progressed far enough and forged ahead so as to compare favorably with the leading power class economically, socially, and educationally. He observed that in such cases, perhaps an upper income ceiling would secure the benefit of reservation to such of those members of the class who really deserve it. So therefore, an income criteria is also recognized by Justice Kaval. And therefore of the view that the state must evolve a policy for identifying the creamy layer even from the scheduled castes and scheduled tribes so as to exclude them from the benefit of affirmative action. In my view, only this and this alone can achieve the real equality as enshrined under the Constitution. In view of the discussions above, the following are our conclusions. Article 14 of the Constitution permits subclassification of a class which is not similarly situated for the purposes of the law. The court, while testing the validity of subclassification, must determine if the class is a homogeneous, integrated class for fulfilling the objective of subclassification. If the class is not integrated for the purpose, the class can be further classified upon the fulfillment of the two-pronged intelligible differentia standard. In Indira Sani, this court did not limit the application of subclassification only to the other backward classes. This court upheld the application of the principle to beneficiary classes under Article 15.4 and 16.4. Article 341.1 does not create a deeming fiction. The phrase deemed is used in the provision to mean that the caste or groups notified by the President shall be regarded as scheduled caste, even if it is accepted that the deeming fiction is used for the creation of a constitutional identity. The only logical consequence that flows from it is that castes included in the list will receive the benefits the Constitution provides to the scheduled caste. The operation of the provision does not create an integrated, homogeneous class. Subclassification with the scheduled caste does not violate Article 341(2) because the castes are not per se included in or excluded from the list. Subclassification would violate the provisions only when either preference or exclusive benefit is provided to certain castes or groups of the scheduled caste over all the seats reserved for the class. Historical and empirical evidence demonstrates that the scheduled castes are a socially heterogeneous class. Thus, the state, in exercise of the power under Article 15.4 and 16.4, can further classify the scheduled caste if 1. There is a rational principle for differentiation, b. The rational principle has nexus with the purpose of subclassification. The holding in Chinnaya that subclassification of scheduled caste is impermissible is overruled. The scope of subclassification of the scheduled caste is summarized below. The objective of any form of affirmative action, including subclassification, is to provide substantive equality of opportunity for the backward classes. The state can subclassify inter alia based on inadequate representation of certain castes. However, the state must establish that the inadequacy of representation of a caste group is because of its backwardness. So, people who do not properly participate in a certain process of recruitment cannot be a criteria. It is the backwardness which disables them from becoming eligible is the criteria that is being referred to here. The state must collect data on the inadequacy of the representation in the services of the state. because it is used as an indicator of backwardness. So therefore, the state as a first step must collect data on the inadequacy of representation in the services of the state. Article 335 of the Constitution is not a limitation on the exercise of power under Article 16.1 and 16.4. Rather, it is a restatement of the necessity of considering the claims of the scheduled castes and the scheduled tribes in public services. Efficiency of administration must be viewed in a manner which promotes inclusion and equality as required by Article 16.1. The conclusions I have quoted again from Justice Gawai's judgment. However, I may observe that taking into consideration that the Constitution itself recognizes the scheduled castes and scheduled tribes to be the most backward section of the society, the parameters for the exclusion from affirmative action of the person belonging to this category may not be the same that is applicable to the other classes. If a person from such a category, by bagging the benefit of reservation, achieved a position of a peon or maybe a sweeper, he would continue to belong to a socially, economically, and educationally backward class. At the same time, the people from this category who have availed the benefits of reservation have reached the high excellence in life cannot be considered to be socially, economically, and educationally backward so as to continue availing the benefit of affirmative action. They have already reached a stage where on their own accord they should walk out of the special provision and give way to the deserving and needy. I may gainfully refer to the observations of Dr. B.R. Ambedkar as under. History shows that where ethics and economics come in conflict, victory is always with economics. Vested interests have never been known to have willingly divested themselves unless there was sufficient force to compel them. The majority opinion from I summarize now is scheduled castes under the Constitution are homogeneous or not. The answer is they are not homogeneous. Is subclassification of scheduled castes permissible? Yes, it is permissible, as Article 15.4 only refers to socially, educationally backward classes, which includes SC/ST. Whether the creamy layer and scheduled castes to be excluded, yes, state must evolve a policy for identifying the creamy layer, even from the scheduled castes and scheduled tribes, so as to exclude them from the benefit of affirmative action. Inadequate representation within public service. Preference can be given from among the scheduled castes, but those are inadequately represented in state services from amongst the other scheduled castes. The law laid down by Judge Bench in Chennai is overruled. So the minority opinion is the state has neither executive nor legislative power to subclassify or subdivide or regroup the scheduled castes enumerated in the presidential list notified under Article 341. The law laid down by the five-judge bench is the correct law and deserves to be confirmed. I think with this I come to the end of my presentation. So the broad indicators are that first, scheduled castes are not an identified caste per se, but are referred to as scheduled castes for the convenience of furthering the constitutional equality for those who are identified in terms of 366(24) and 341 and included in the presidential order for the state or the union territory in question. 2. Subclassification is also read in as a matter of constitutional recognized principle of furthering equality amongst certain subsects of people also who are part of the presidential order. Again, how to go about that is the question. That is where the real anxieties, as I see, can come from. How to go about implementing this judgment which recognizes non-homogeneity and permission of subclassification. That needs to be preceded by a very detailed study of adequacy or inadequacy of representation from amongst the identified groups within the presidential order. So the referral population here, unlike the backward classes where the entire population is to be looked into, here it will be a subgroup of the castes included in the presidential order, and within them how adequately or inadequately these sub-identities are represented or not represented. An empirical study and data have to be there before the state government before they can take or formulate a policy to actually further this declaration of law into action to identify the real people who still suffer the social backwardness on account of their birthmarks, as contrasted with people who have had the benefit of this affirmative action and who have climbed the ladder and gone into positions of power, influence, including to be the lawmakers or probably the policy makers in the society through the constitutionally recognized modes. So the income criteria is also a relevant criteria for social backwardness, is how the court has recognized. So therefore, we have an income criteria and also the kind of opportunities availed and the status that has been achieved by the people who are considered to be a group who have lost the connect with the others within their caste also. So what we are talking about here is a caste, let's say X, has 10 people, out of which 4 people make it to the Union Public Service and Group A, IAS, IPS, IPS, or any of those Group A services. 3 people make it to the state grade gazetted officers and above. The remaining are all probably in the grade 4 or below as contractual laborers or whatever. So now within that subcaste of X, how is it to be worked out? Because all of them belong to the same subcaste. So is it permissible that the entire subcaste be removed, though there are still people who are socially backward within the subcaste? Or applying the principle of creamy layer, only such individuals who have received those benefits are excluded by application of the creamy layer, is a matter for the government to formulate a policy on some reasonable classification amongst that category of people who are included or excluded, and then that classification should have a nexus to the object of furthering the constitutional mandate of providing equality to the deprived and the depressed classes who still are waiting for their share of equality in a constitutional democracy after 75 years. I think with this, I come to the end of my presentation. Thank you very much for this opportunity.
Thank you, sir.